In March 2022, Marilyn Manson sued his ex-fiancé, actress Evan Rachel Wood, and her ex-girlfriend Ashley Illma Gore. In response, they claimed free speech protections, known as anti-SLAPP, against Manson's allegations. A judge later struck some of Manson's claims, one including allegations about a fake and forged FBI letter and FBI impersonation. Currently, Manson is appealing the lower court's ruling. I spoke with Andrea Burkhart, a YouTuber and criminal defense attorney, about the FBI letter issue, the judge's decision, and what we might expect to see during the appeal.
I wanted to ask, since you are an attorney and you've read these legal documents, what are some things you expect to see in the opening briefs that would be challenged? For example, the FBI letter and Gore not challenging that, or there was also hints of King collecting transcripts. So what could that mean? To me, that means that possibly the judge erred in some way in some rulings, but we don't know until we see them.
With respect to what I'm looking out for, I think you hit the nail on the head with the big, obvious problem with the judge's ruling, which is that ostensibly now the complaint has been modified to eliminate all of these allegations that relate to the FBI letter. And the reason why is because Evan Rachel Wood challenged that. Illma Gore did not. And the reason why that ruling went in favor of Evan Rachel Wood is because she filed that FBI letter in her child custody case. That's how it kind of came to light. That was the action that she took, that Manson is pointing to and taking issue with. So for her, having done that in the context of an existing court case, it's covered by litigation privilege. You get to say what you want to say in court, and you can't be sued for defamation or anything like that. The exception to that is obviously you can't commit perjury. So there's a lot of overlapping issues with this anti-SLAPP ruling in favor of Evan Rachel Wood. She has this litigation privilege, but it is a crime to commit perjury. But the way that the trial judge analyzed this issue is that, well, under the way the anti-SLAPP law is written, the case law as it's developed, you only get to rely on somebody's illegal conduct if it's undisputed. And since Evan Rachel Wood contests that she committed perjury, then you don't get to say, well, she committed perjury and therefore she's not entitled to claim the litigation privilege. It's very bizarre to me, just from a logical standpoint, because clearly now you're protecting somebody doing something that would not, if it's true, be protected by the First Amendment. Lying in court is not protected by the First Amendment. So from a logical standpoint, it's challenging, to get there. But the judge did seem to have law in the ruling that, supported the outcome that she came to. It's just very strange law. So there's a possibility, always a possibility, that can be revisited on appeal. The courts can say, actually, you know what, this is kind of crazy. Maybe this isn't, the right test or something like that. So that type of outcome is possible. But the bigger concern here is it's only Evan Rachel Wood who was involved in that court case who would have the litigation privilege. Illma Gore didn't have it and, can't claim that. And she is, according to Marilyn Manson, complicit in creating this thing. They have what he claims are text messages between her and Evan Rachel Wood, basically showing them in the act of crafting it. So she can't claim litigation privilege. So it seems to me like then he can still assert his claims based on that letter against her. She's not a party to the lawsuit. But the way that the judge wrote the ruling is just these allegations are out entirely. These causes of action are out entirely. And it seems that at a bare minimum, he should be allowed to proceed with those claims against Illma Gore. She didn't argue that position, and she's not in the same She's not in the same position as Evan Rachel Wood legally to be able to claim that litigation privilege. So that's where there is, I think, a pretty good argument for him to make on appeal that at the very least that part was wrong, that throwing out the cause of action altogether was not correct. It's not supported by the ruling that she made. Maybe throwing it out against Evan Rachel Wood, if we're going to uphold this weird reasoning about perjury, you know, only if it's uncontested. But you would still be able to go forward against that with Illma Gore. So I do anticipate that being very likely to be one of the issues that's raised on appeal.
I think Gore claimed protected activity on working for the Phoenix Act, and certain allegations, including minor, was protected under the guise of her being employed, even though her deposition, she said she was not employed by the Phoenix Act.
There's different types of privileges that people have, and so litigation privilege very specifically deals with being involved in a lawsuit. So unless Phoenix Act and her or her whatever is involved in a lawsuit, you don't have litigation privilege. Now, you might have a privilege based on testimony given to a legislative body, right? So like going and testifying before Congress, it's not litigation, but it's a similar type of context. You're there, you're under oath. And so for the same reason, you can be compelled in to do that type of thing. For the same reason, that will often receive a similar type of privilege. But I don't know that any of this has anything to do with Illma Gore giving sworn testimony to any type of legislative body. Evan Rachel Wood did. We saw several times in California, in the U.S. House of Representatives. And so there's likely to be some privilege associated with those statements as well. But Illma Gore has not been really out in public doing this type of thing.
Do you believe the FBI letter is fake? And there is an actual reason why I'm asking this. I don't think anyone is disputing that in legal documents that this letter is fake.
Mm-hmm. I mean, the person who ostensibly wrote the letter says it's fake. That's pretty persuasive to me. You know, we have a sworn statement from somebody who spoke directly to that FBI officer who insisted, yes, it's fake. I didn't sign this. It doesn't look much like you would expect an FBI letter of this type to look. It looks like a, you know, informal thing that got pieced together on like a draft form. It's not on letterhead. It's not very well formatted. I mean, there's a lot of reasons to be suspicious of it. But to me, yeah, the bottom line is the FBI officer apparently denies writing it. So that's pretty dispositive. That's the thing too, is especially for official communications, you know, in the course of your work, your business and stuff. Yeah, those need to be on your official stationery. I mean, they need to be associated with your official business, your office. You can't just be sending stuff out willy-nilly with, you know, this kind of weird attribution of, who is this even from? It's got multiple names on it. Who's the author? Yeah, it just did not look like anything I would expect to see from a law enforcement agency.
Even though it's an appeal, do you think it's still worth discussing the FBI letter, whether it stays or not?
Well, I think so. And I've mentioned this before. This is something that Steve and I don't necessarily see the same way on, but neither of us is really sure how it's going to go. And that's whether the FBI letter can still be used as evidence, even if it can't be a cause of action, you know, specifically supporting a claim that he's making against her. Steve takes a position, which I think is pretty reasonable, that you go through this whole anti-SLAPP process to determine what conduct is kind of within limits, to question whether it's a valid First Amendment activity, or whether it's you know, supporting a claim. So it doesn't make a lot of sense to say, no, this is protected First Amendment activity, but you can also, you know, go ahead and continue to discover it and use it against the person at trial. I think that's a reasonable position. The problem is just that it's still relevant to show show state of mind, show modus operandi, show malice. It's relevant to a lot of things in the case, even if it itself is not the basis for a cause of action. And a lot of things that people do are, protected First Amendment activity. Maybe I can't sue you for it, but I can still use it, as proof against you at trial, things that you say, things that you do and stuff. So I think that there's still a decent argument to be made that just because you can't base a claim off of this doesn't mean that it's out of the case entirely, that they aren't going to have the opportunity to raise this and point this out as, why were you making up this claim of an FBI investigation against Marilyn Manson? And then how does that fit in with this scenario where you have created these kind of evolving claims against him after having denied for many years that he did anything inappropriate in your relationship? Then suddenly that changed. And then the details of your allegations begin to change. It's just a little bit too close to the core of what happened with her accusations, to me, to just leave that out of the picture entirely and expect that not to be misleading.
I don't know if I've asked this before in the past, but my question is, what would happen if the FBI letter comes back and appeal for Gore, but not for Evan Rachel Wood?
Well, there's a couple of ways that could be handled. One, they could sever the case. They could just sever the defendants instead of having one single case against both of them. You have separate cases against them both. The court's probably not going to want to do that because whenever possible, you want to do things once. You don't want to do them twice. And so when there's so much overlap, you don't want to have two trials about essentially the same thing. So another possibility, which is probably more likely, is just that gets addressed in the instructions. The jury is told, you get to consider this against Illma Gore. You don't get to consider this against Evan Rachel Wood. You only get to consider it against Evan Rachel Wood for purposes of, evaluating her motive, state of mind, etc. That's the more efficient way to handle it. It's probably a little bit of a fiction to assume that a jury is going to sit there and compartmentalize like that. I mean, if they hear it, they hear it. And, if you're hearing that the person sitting in front of you did something that, is potentially criminal, it's going to be kind of hard to not sort of hold that against them in evaluating. So were you intentionally inflicting emotional distress on Marilyn Manson? But that's sort of the fiction that the jury system operates in, this assumption that we can tell them what the law is and they'll be able to put aside their own feelings and just decide the case consistent with how the judge tells them the law requires them to consider it.